Yes, Mrs. I've dealt with the patent. I was going to address what the judge did on the construction. So we're in the judgment. It's tab 8, the core bundle. You've seen some of these passages this morning. Your Lordships know that he turns to the issue right at the foot of page 137 and basically gets into it at the top of 138. And he sets out the entirety of paragraphs 22 and 23, having identified the issue. And what he's done after setting those out in paragraph 137, so I'm now at the foot of page 138, is explaining that when you look at the whole of the text, including the wording he's put in bold, it's clear that both of the alternatives that he'd identified above are being encompassed. And the wording that he emboldens are first, he emphasises the wording in para 22 of what must comprise the plurality of portions. You see, he's emboldened the words, the one or more electrically conductive tracks. So that's basically making the point about it falling in the language if one understands that it's covered by those words. What's covered by those words must comprise a plurality of portions. Next, the judge has emboldened the wording at the beginning of paragraph 23 that makes it clear that the wording in the middle is just one embodiment, and in fact one with a single track. And third and lastly, the judge has emboldened the last words of paragraph 23 that make it clear there's another embodiment contemplated. That's the point that I was debating with my Lord Justice Nugee just before the adjournment. Now, my Lords, it doesn't stop there. He went on and addressed the technical purpose as described. This is the middle of paragraph 137, where we see the judge explaining that all the advantages articulated in para 22 regarding portional heating also pertain where you have multiple tracks, each being separately controllable. And the judge continues on technical purpose over the page in paragraph 138, where he explains it's entirely unsurprising that both arrangements are articulated or encompassed. And we see the reason he gives are founded in the technical purpose. It doesn't matter how one achieves portional heating. Just what is the point of the restriction my friend urges on you, we ask? None, which is basically what the judge is saying in 138. So, my Lords, the upshot is the judge's approach is in fact entirely conventional. He addresses technical purpose and language, including the specific explanation that multiple tracks separately connectable were included, and he came to the correct conclusion. The claim covers both arrangements, and as I said before at the short adjournment, would indeed cover a mixture with some tracks of each kind. What's not required, where one has a plurality of physically separate tracks, is for each track to have this further division or split. And that's basically what I showed you the opposition division concluded this morning as well. But my friend has to frame the invention like that, where the tracks have to have separately connectable portions. Now, Lords, can I turn to the next point in my argument, which is that the dispute as to construction in any event has no effect on the judge's conclusion as to obviousness. And that's because he plainly hit the claim on both alternative scopes, broad or narrow. And let me show you that. It's para 138 that we were just looking at to 139, and actually the nub of it is the combination of it in 139(3)(e). Just to navigate my Lords through that, para 138 is where the judge turned to the issue. He explains at the start of 139 he had no doubt heating portions would be obvious. Might also add it's part and parcel of what DV is disclosing and what was part of the CGK devices like a cordon heat bar. And the judge sets out some key evidence from either side's experts in subparas 1, 2 and indeed 3a. The first extract, so 1391, is as common general knowledge of thin film heaters by the priority date, including, you see in the middle of the extract, the heating of particular portions by applying the current to the pathway covering that portion. In other words, separately connecting a portion to the power to heat that portion. The other extracts, that of my friend's expert in subpara 2 and the explanation of what my expert said in subpara 3a, are expressly directed to what would be considered in the light of DV. And I'll come back to that. I'll just mention it at this stage because another criticism is the judge was muddling up what was obvious in the light of the patent's disclosure. And it's untenable in my submission, but it's important perhaps to note that the context of all these paragraphs is what's obvious over DV. The judge ultimately concluded the skilled team would move from DV's throwaway insert to a tubular permanent heater. He explained that in subpara 3e. He said it was entirely straightforward to translate the proportional heating functionality to the heating tube. He specifically concluded that a single track with controllable portions and multiple tracks, whether with portions or not on the same substrate, would both be obvious. That's the last 4 lines of that subparagraph. So the upshot is his conclusion as to what's obvious hits both scopes of the claim, according to my friend's construction or his construction. Now, my lords, just looking at my friend's summary of points in paragraph 2 of his skeleton, I've dealt with the reason the judge has not misconstrued the claim. I've just explained how he has in any event hit the claim on either construction. So he didn't ask himself the wrong question as a result of his construction. In substance, he asked himself the question both ways round. Would portional heating be obvious, and if so, whether the narrower way of achieving it would also be obvious, and it was. Can I move to consider the third point articulated in my friend's skeleton in paragraph 2, which, as I've foreshadowed already, is a suggestion that the judge muddled himself up and basically was asking himself the obviousness question over the patent's disclosure. And the reason, as I understand it, the point is made is because he referred back to the 2 ways you might implement portional heating that he'd identified earlier in the judgment by referring to paragraphs where he was dealing with it on construction. And as I understand it, the suggestion is because the reference back is to a passage where he was addressing construction, he must have been considering obviousness not in the light of DV, but in the light of the patent. Well, that's a completely unfair reading of this paragraph, both in isolation, but even more so when one sees it in the context of the rest of the part of the judgment that I've drawn attention to. It's plain that this is simply referring back to ways in which he'd identified the 2 ways in which you could implement portional heating, specifically the single track with intermediate segments, separately connectable or separate tracks. He's simply doing that by cross-reference to say that both of the things I'm talking about back there are obvious. He's plainly not saying that it's obvious in the light of the patent's disclosure. My lords, look, that would be a funny thing to do, given that they're actually disclosed in the patent. Why would you say it's obvious? He's not doing that. He's clearly looking at those extracts. He's clearly identifying that difference as what he's talking about, but still focusing on what's obvious over DV in the light of the CGK. And that's what he's referring to in those paragraphs running up to it.
There is an area that you can fall into, can't you, by asking the question by reference to something which is disclosed for the first time in the patent. What you should be doing on analysis of obviousness is simply asking the open question of what it's obvious to do in the light of the prior art. if you include in the question a heater with multiple portions, is that obvious? You're providing the answer before you've asked.
That's the problem with the Pozzoli analysis, said my lord.
No.
Identifying the difference. My lord's absolutely right in that you're asking yourself a question which is focused on the thing that matters for the case because you know what's in the claim. But it's inherent in what you have to do. And he knows that my friend is saying that it's one rather than the other. So he has to ask himself, do I hit both? And how do you do that without asking yourself, do I hit the other alternative? He has to do that.
Oh.
It doesn't mean...
Whereas it's quite easy to see why the multiple tracks would come out of DV. It's not quite so easy to see why you'd modify DV to have separate portions within an individual track.
Well, they're both different ways of achieving exactly the same thing, which is...
But why would you go for the second?
You might choose, particularly, what you've got to bear in mind, my lord, is that around this issue as well is my friend's argument that actually having a common connector is having a single track with portions. So that might be one way in which you're doing something which falls on what he says is the other side of the line. But they're two straightforward ways of basically connecting up lengths of conductive material which are going to have current flowing through them at different points in time, which, because they're resistive, are going to heat. And you do either. The criticism that's specifically put is because he refers to a part of the judgment where he's identifying these alternatives in the context of construction, he must be muddling up the question. Yeah. And I say not at all. And the point that my lord put to me would apply equally if he'd identified it by not referring back. So it's just not a fair reading of the passage as a whole in my submission. And that brings me to the fourth point in the articulation of the judge's errors. And it says the judge was wrong to conclude there was no material difference between having separate tracks without portions, meaning the individual tracks not divided, so separately connectable, and a track with separately connectable portions. So again, it's built on the same distinction, and they say the judge was wrong to conclude that there was no material difference. I have to say I'm not sure that this really is a separate point compared to what he was saying on construction, because I think he was trying to rely upon this kind of argument on construction. And it's said that it's an error because there's a suggestion that separately connectable portions in a single track provides greater flexibility in the heating profile that can be used for any part of tobacco, as well as reducing the number of connections. So there are 2 points that are made there. Addressing those 2 points. Firstly, the alleged greater flexibility in the heating profile. It's important to remember what we're comparing here. And we're not comparing the basic system where you heat everything all at once and, or not at all. We're comparing these 2 different ways of heating portions. The plurality of physically separate tracks, or one physically contiguous track with different regions that can be separately connected up. And there just isn't any greater flexibility between those 2 alternatives. And my lord asked my learned friend just before lunch what it was. And he couldn't identify anything. He said you can get the same heating effect. So that's just wrong, the first half of this point 4, and he couldn't maintain it when you pressed him on it. The second half, which was all he actually said in response to my lord's question, fewer connections. And I think the idea that he was conveying was that for the separate tracks, you need 2 connectors for each track. And you might be able to do it with fewer if you have a contiguous track and tap it off, because one connector can do double duty. You can use the middle one for that bit, and then you can use the middle one again. Hardly earth-shattering, but in any event, it's wrong. And you can see the suggestion that there will be fewer connectors with single track arrangement? Best answered by considering the DV arrangement. Remember, my friend says this is separate tracks, not single tracks. DV, he says, are separate tracks. And there are two embodiments in DV, and we can actually just take them from the diagrams in our skeleton. The first is on page 11 of our skeleton, which is 34 of the bundle. And I think my Lord Sir Christopher Floyd is alive to this. This is separate tracks. You haven't got two connectors for each track. You've got a common connector across the top, the purple one, which then comes down the side to connect on. And then one extra connector as a dedicated track to each tooth on the comb, as it were. So n separate tracks, n plus 1 connectors. Happens to be the same on our infringement, but the point I'm answering here is it's just not right. On my friend's case, this is separate tracks, to suggest that you can go to fewer connectors than you'd need for separate tracks, because here's one with what he says are separate tracks, which also has fewer connections. It's even worse if you look at the other embodiment in DV, because this is if you go back to page 30 of the bundle, page 7, this is a way of doing it where you have switches which switch on at different points in time to heat different resistive heaters. But the point here is you only have two connectors. The red line and the yellow line either side are the two connectors. That is it. So if you're a bit clever about it, you can even get it down lower. So, my lords, the fourth and final error, there's just nothing in it. The first half of it, my friend couldn't maintain orally, and the suggestion that there are fewer connectors is just, firstly, it would not be earth-shattering in any event, but it's just not right. There are ways in which you can have these configurations that my friend says are separate tracks with a number of connectors way below 2 for each track. So that's the fourth and final point of principle that the judge has suggested to have erred on. And also, there really is nothing in this appeal. It's an attempt to re-argue the assessment about wanting to have, being obvious, to have variable duration and time. It's been dressed up as these points of principle relating to portions, but the core of what he's trying to get at is to re-argue, revisit that central decision. I've got to the end of my note. Are there any other issues that I can help my lords?
No, thank you. Mr. Nicoventures, any reply?
Lords, I'll start the reply with the new construction on the patents. My Lords may have seen on this side of the court a certain surprise in that this is a construction that's never been advanced before. It wasn't advanced before the trial judge, and it wasn't advanced in the appeal skeleton arguments. It seems surprising because actually the appeal skeleton argument didn't just go softly on the issue. It actually, the appeal skeleton argument doesn't even trail the new construction.
It's not a new construction, he's supporting the judge's construction. Now, you're right to say that the skeleton argument scarcely made it clear that that was the position being taken. But he's entitled to say that the judge was correct, is he not?
He's entitled, of course he's entitled to that, my lord. The reason I say it was new is that the reasoning behind the judge's construction is new, in the idea of using a composite phrase of a plurality of effectively one or more tracks being a composite phrase of which portions then are, each track can be a portion within that composite. That is new and has never been trailed or ever mentioned. It is not, in my respect, position what the judge was saying. And indeed...
You're saying it's not open to him?
Well, my lord, what we're saying is that if he's going to run it, and he has run it, then of course issues might have arisen if my lords are with him on it as to whether or not we would have amended, for instance, to a single track with multiple portions. I'm
a bit puzzled by that because suppose you're correct that the reasoning that Mr. Speck advances is new, nevertheless, the result for which he is contending is that which the judge arrived at.
My lord, I hear what my lord says, and that takes me to our next point, which I've already addressed you on, which is that we say it doesn't make a difference to the obviousness finding on this patent, because we say it remains the case that, for the reasons I've addressed you on, that over DV it is not obvious, assuming you're with me on the construction of DV, that it does not teach different durations or temperatures for different tracks, then it makes no difference either way, which is of course where both parties, or my learned friend, started in his skeleton. So one must not get too hung up on the difference. Plainly, if we are right on construction, there is an additional hurdle, which is that you need the portions. But one has to put the importance of the point in context with the findings of obviousness. On the amendment, on the construction, we say it is not right, and the reason no one raised it before is it entirely contorts the language of the claim, and effectively it means you have to read the claim as this composite phrase, one or more electrically conductive tracks. But if one looks at the claim, it uses different words for the different components. So a heater as a whole is different from the tracks that make up the heater. So you have at least one heater comprising the tracks. It's one or more electrically conductive tracks, and the one or more tracks comprise a plurality of portions, and each of those portions are then connected to be heated. And we say it's just too far an abuse of the claim language to say that if actually you get double duty, that a track is a track. If there's more than one track, a track is also a portion. And we say that plainly is not a fair reading of the claim. The reference in paragraph 22 to the referring to it allowing a portion of the heater to be activated is true, it does. But heater and track are not the same thing, and the claim is clear on that. And so it does allow a part of the heater to be heated, but the claim goes out of its way to distinguish between heater, track or tracks, and portions of the track or tracks. And we say the issue that my learned friend now has is it effectively rewriting the claim, and it makes track and portion intertwine. We say, therefore, that it's not unusual, it's not exemplary, it's not something one wishes to happen, but it's not unusual for there to be embodiments discussed in a specification that are not claimed. And we say that is the position here, and what the claim has, the patentee has elected to do is to claim tracks with portions. But as I say, my lord, as I said in opening, we're not basing our appeal on obviousness on this, and we say one then turns to DV. We say one doesn't hit either scope of claim, and that's how I addressed you before. And if I turn now to DV, my learned friend put his case orally, again differently than was put below or by the judge or in his skeleton, which is focusing on the manual, primarily on the manual embodiment of DV. And he said that he said there's evidence that the switch means that it lasts, the heating lasts for as long as the user wants to puff. So effectively you hold it down for as long as you want and keep it going. What he never said or addressed you on is what on earth would be the technical purpose of that in a product which has these tiny coatings of material, which therefore you would just simply be heating a heater with nothing left on it. And that I showed you was the technical reason why Mr. Hobbs said that can't be right, as well as the overall disclosure. He also ignored the fact that that EV itself, when it talks about this, says the user presses the button to initiate heating, which is correct, and it initiates it and fires it for the fixed period of time of DV. DV is very clear, and I've shown you that it is a pulse heating device, and it says very clearly that both the energy and the heating is done for under 1 second, for 450 degrees. And of course, he can't avoid the fact that both experts agreed that DV is talking about fixed duration heating. And that's not just the language of the claim, which is not for the experts, but it's because of the purpose of the document and how you'd understand it. And we add to that, it's how a skilled person coming to read this in 2006 would understand it, because of course it's exactly what they're used to in the accord and heat bar. So what my learned friend is positing is an idea that a patent which teaches either depositing a very small amount of material, or even so small that you make it as a slurry, that says you burn that off in under a second, might suggest that it's a good idea for the user to hold the heater down and keep it on for as long as they want. And neither expert said that. It makes no technical sense. And my learned friend, I raised the fact it made no technical sense, and my learned friend did not address that at all. So we say he's plainly wrong on that, and that of course affects the point about whether or not it's important on the construction point, because we say DV does not teach or hint at a way of moving away from flash or pulse heating to heating either one or more tracks at different temperatures or different durations, and it certainly doesn't teach one or more tracks with different portions heated to different temperatures and different durations. And we say that once that goes, and we say it should, and one understands the teaching of DV, then there is nothing in the common general knowledge or DV to make anyone change course. And my learned friend said, well, there was this evidence on preheating, and I said to you that he might go to that, this idea of, he put to Mr. Hobbs, of preheating with a control loop. This arose from this other case with the evidence of Dr. McLaughlin, which was looking at a bulk heating device, not flash heating. And I said that Mr. Hobbs did not agree in relation to DV. He agreed again that these are all things one could do and would know about as general engineering. My learned friend didn't take the bait to actually go to the part of the transcript where he put DV and this point to Mr. Hobbs. And that is in tab 11 of the supplementary bundle, page 309. Page 309, this is part of the cross-examination about DV, and my learned friend had 170, line 21, put him something Mr. Wensley had said about secondary paths that might appear in the circuitry of DV. And then at 1713, he said, of course, it may be considered beneficial for a bit of preheating, yes? And Mr. Hobbs said that would depend on the specific layout of the arrays and paths. I'm not sure it would be entirely beneficial in a system like this, if it needed to flash off these flavour generating mediums in less than 1 second anyway. So he's, as I said, what he said in his evidence was, yes, you can do this, but preheating doesn't make sense in the DV arrangement. My learned friend then went on to say, it depends what you're doing. but certainly in terms of a heater where you want preheating, of course he's loading that into the question, you suddenly want it may or may not be something you would encourage, agreed? In this system, I would not see the benefit. And that's why the judge didn't refer to that, and I showed you the judge didn't find it helpful, because it's trying to take these general concepts from another case, apply them here, and again, one only has to think, well, why is one preheating a flash heat product? And what's built into it is you've already decided to change it from a flash heat product to a different product where you heat for longer time, different durations, different temperatures, and then other issues may arise. Control circuitry, preheating, and the like. And then, I think, my Lord, therefore, we say that this my learned friend, this new construction or new reason for the construction, is not correct, and it's too great an abuse to the language of the claim. And the language of the claim remains important in defining the monopoly. We say even if we're wrong on that, my learned friend is wrong, and the judgment was incorrect on DV, and it's wrong to suggest that DV teaches different durations or different temperatures for different tracks. And once you have that, then what you're left with in our submission is the judge saying, well, all these things could be done, and they are all old technology, they're all out there, and we say actually that supports obviousness, doesn't go against it. And the judge did did at least ask himself at the end of the judgment, why was it not done before? And my lords, see that at paragraph 142 on page 141. And again, it shows that what he had, we say, it shows again just what he had in mind was making a cord heat bar. And at 142, what he was asking himself was, well, why did no one ever use a thin film heater, the heating tube, as described? And he decided in the middle there that the heating tube is actually not that dissimilar to a cord heat bar. Much return on the insertable and the heating profile applied. And that cord wasn't successful, and so maybe that's why no one did it. I mean, that actually is going against obviousness more generally. But it shows that throughout this judgment, he's looking at, is it obvious to put a thin film heater around a cord? And everything else, he leads to trial and error or reasonable skill, without actually thinking, why is it obvious to do it? And we say that's why he erred in his approach, and he misdirected himself, and why we say it's appropriate for this court to allow the appeal.
Very good. Thank you all for those commendably concise submissions. We will consider our judgment, and it will be circulated in the usual way, that is to say, in advance of a remote hand-down under embargo. As I'm sure everybody in court is now well aware, the embargo is to be strictly observed, and the purpose of the exercise is to point out spelling and syntactical mistakes, not to re-argue the case. If you are able, in the light of the draft judgment, to agree and order consequential upon what we are going to decide, so much the better. If there's anything you can't agree, please put in brief written submissions.